Last but not least, hometown, Harris County, where they are doing juvenile right, is in the house. All right, our last session is highlights, LEAP, and I'm now forgetting, learning, education, an innovative alternative, obviously, to inpatient juvenile competency, a groundbreaking community-based program that provides legal education. That's what it is. Legal education, attainment program. So LEAP is Legal Education Attainment Program, which is obvious by the name, but I couldn't spit it out. Competency restoration services to youth without the need for inpatient placement. Please welcome our presenters, Dr. Uche Chibueze and Dr. Florencia Iturri with Harris County Juvenile Probation Department, and Dr. Toni Walker with the Harris Center, which is also connected to, and I'm so jealous, to present to you the Harris Center and all that they are doing for youth in their community, and we are copying as fast as we can. Thank you.
Stand when I present, if that's okay. All right. Well, thank you, everybody, for giving us the opportunity to talk about our program and fitness attainment services in the juvenile world. And so we're really excited to present this, especially since we're in Harris County, where the LEAP program was developed. So first thing I want to do is to go ahead and talk about competency restoration as a whole and how we got to the part of where we are right now. How do we advance? There it goes. All right, so what we're going to do today is really just talk about some of the challenges that are associated with competency restoration and how that applies to the juvenile world. We're going to talk about some of the creative solutions that we were able to come up with and how we were able to implement it. And those of you guys that are in other jurisdictions, how you can implement something similar in your jurisdiction. So really talking about the need that also presents in the juvenile world. All right, so as I talk about juvenile court and adult court, you'll hear me interchangeably use competency restoration with fitness, all right? So, but fitness is really what's going to apply to the juvenile world, but I'll just use competency a little bit sometimes just because that's what most people are familiar with. Now, as you know, competency restoration for adult stems from 46B. For juvenile, it's going to be the Texas Family Code 55, Chapter 55. Sorry, so when you hear me talk about Chapter 55, just know that's where the language is going to lie and how we procedurally address fitness in juvenile world. Oh no, I missed it. Okay, so anyways, one of the things I do want to make sure that you understand, what is competency and what goes into it? And does it apply in the juvenile world? Well, competency is really something that is going to look at one's ability to actually participate in the legal process. And this can be brought up at any point during the legal process, and that's important to note. All right, it's not just at the beginning, it can't just be just in the middle or at the end, it's at any point. And it's something that we've already realized is very important to raise. Now, there's a competency test that most people are familiar, especially if you do adult work, and it's going to be the Dusky test. Now, Dusky, this case happened in 1966, and it basically outlined what do you look at to determine if somebody's incompetent to stand trial. Because prior to this, what they just did was what we call like an exam just to see mental status. So those of you guys that know what a mental status exam is, like, do you know your name? Do you know the date? Do you know where you are? Basics, all right? Well, that's not enough to determine if somebody has the actual capacity to be able to participate in their defense. And so what they developed in Dusky is to identify what are the prongs, what are the features that we have to assess for to determine if somebody is incompetent to stand trial. So we got the two-prong test that we speak to. And that looks at somebody's rational and factual understanding to be able to assist in their defense and to understand what's going on in the legal process. I do want to pay attention to this a little bit. This is adult language, right? It's going to say if the person has present is a key word, sufficient ability to consult with their attorney and with a reasonable degree of rational understanding to be able to also have rational and factual understanding of the legal proceedings. The reason why I'm honing in on present, it's different in juvenile world. All right, in juvenile world, a lot of our kids may not have been exposed to legal processes, so they may not have present ability. All right, that doesn't mean that person is not fit to move forward in the process. So you'll see in the juvenile code, it uses capacity. And that's also something to pay attention to when we're looking at restoration. And you'll see that people that do juvenile work, especially when they do the evaluation, they have to do a lot of teaching because the person may not necessarily have been exposed, right? But that doesn't mean they don't have capacity. All right, so competency, one of the things you have to pay attention to is very task specific. And what I mean by that is different people have different mental loads requirements depending on what they're facing. For example, if I have a kiddo that's here for aggravated robbery and they're taking it to trial, their burden is a lot higher than I have a kid that's trying to stip for possession of marijuana. All right, so when I'm doing a competency evaluation or a fitness evaluation, I have to take that in consideration, all right? Because I'm gonna have a little bit of a higher standard for somebody that's going to have to do more in part of their legal proceedings. It's also moment specific. I can have somebody that's competent today, something happens and they're not anymore. All right, so sometimes you may say, man, this kid was fine. And now you're saying they're incompetent or they're not fit to proceed. It is very moment specific. All right, so that's something always to pay attention, which is why it can be raised at any point. Also, diagnosis does not determine incompetence. This is a big one. I see this in evaluations all the time. Oh, the kid is unfit to proceed because they're IDD. And it ends there. All right? That cannot make somebody not fit to proceed. It is a reason, potentially, all right? But it's really based on their functional capacity. So how does the diagnosis impact their ability to understand and to be able to actually participate effectively? So if you have an evaluation that says the person is unfit to proceed or incompetent just by nature of the diagnosis, then it is an incomplete evaluation. All right, so that's something to pay attention to. Also, as I mentioned before, the threshold is going to be based on the task at hand. Does competency apply to juveniles? Well, most states recognize it does. We have 37 states, including Texas, that actually has in their code references to competency in regards to children. So that's a good thing. And the reason why it does that is Kent versus United States, which is an important case, especially for certifications. It's one of the cases that allow for due process for juveniles. And then also the Galt case. Anybody know what happened in the Galt case? I don't know if anybody's a big buff on legal cases. He did something so bad. He made a lewd phone call, basically. And when he made a lewd phone call, it was a prank call. And, he got caught. Well, he said it was his friend. And he went in front of the juvenile court. And the judge says, you're doing the most, sir. So I'm going to sentence you to what our equivalent would be of TJJD until you're 21. He was 15 at the time. So he got 6 years for making a prank call. All right, so those of you that are in the years before caller ID, used to get away with that back in the day, not so much anymore. All right, but what that basically said, that violates his due process rights. All right, and basically says that juveniles should be afforded the same due process rights as their adult counterparts as well, which includes competency. There's a lot of good research that looks at what restoration and competency is looked at in other states. Most states actually do not raise the specific guidelines of when you can raise the issue of fitness. In our statute, what it says any party can raise the issue, even the judge, upon assessment, all right? So that's important to note. A lot of different jurisdictions have questions as to how that happens, that mechanism. One of the great things about Harris County is that we have an in-house psychologists from the Harris Center, primarily, who do testing and help alert the parties as to whether there's an issue that could be addressed with competency. So that's a great mechanism. 25 states also talked about what is the recommended length for fitness restoration or competency. So in our statute right now, we have, anybody know what the recommended length is? 90 days, all right? So 90 days is typically the recommended length for restoration. One of the things I do want to see in the near future is to see if we're going to have different lengths for inpatient services as opposed to outpatient. So we'll talk about a little bit like some of the barriers and some of the difficulties in outpatient services and why you need a little bit more time to allow for restoration. Because usually that 90-day it's a little bit harder to reach, if that makes sense. 11 states have some age-based assumptions of incompetence. So one of the research, it basically says that kids that are under the age of 14, especially if they have any kind of intellectual impairment, are more likely to be found incompetent or unfit to proceed. So a lot of the states use this research to determine that any kid in that certain age range are automatically considered incompetent, and then you have to prove competence, which shifts the burden a little bit. Texas doesn't do that yet. Also, a lot of times, what we see as well is that they'll use some of the adult language to apply it to juveniles, and they don't have specific language for juveniles. One of the great things that happened with the reform of Chapter 55 is that we had more specific juvenile language, which is great. All right, so I do want to talk about a little bit of what some of the state needs are. So in Houston, or in Harris County, we are the largest county, but we do have a lot of kids that go through fitness restoration, and competency is raised. But we are not the only people. Obviously, there's a lot of different jurisdictions where we're having the same issues. And so a lot of places and a lot of options were really based on inpatient up until a certain point. So state hospitals, state-supported living centers have exorbitant costs if we were going to send the kids there for restoration, and they have limited beds. All right, so that's something to pay attention to as something we got to look at alternative options. Right now in the state hospital, what we're seeing is an average length of stay of 90 days if they are being restored. The daily rate is, the last time I checked, you can tell me if it's different, was $906 per day, which is quite expensive. And then also the wait time is 4 to 8 weeks for the state hospital. For state-supported living center, we're seeing even longer waits. I have a kiddo right now who has been waiting about 6 months for a state-supported living center bed. And so looking at capacity, state-supported living center had a number of juvenile justice admissions per year. It was about 23 in 2019 and 18 in 2024. And I'm going to talk about some of the numbers that our needs in just our jurisdiction could also by itself put a load on the system. So in 2019, we have about 8 youths who were referred for juvenile Chapter 55, so if they're unfit to proceed for either inpatient services or for outpatient services. 2025, those numbers have been updated. Right now we have 18 youths who were referred for Chapter 55 services, 8 youths for inpatient services, and 8 youths that are using our LEAP program. So if you notice, take out your COVID years, you're gonna see an increase of youths needing Chapter 55 services. I don't know if anybody's seen something similar in your jurisdiction, more kids needing Chapter 55 or being referred. Yes. And I always tell my students that are in grad school, if you could do some good research as to what happened after the pandemic, that we had higher kids with higher support and acuity needs, that Chapter 55 became more of an issue, which is one reason why we need alternatives to just inpatient services. I know we have a presentation happening concurrently right now talking about how in the adult world, how they address the wait times. Which is great with adult jail-based competency restoration services. Okay, so we need something similar in the juvenile world as well to eliminate the wait. One of the things that we ended up doing is addressing some of the main needs, increased need for competency restoration, address the long waits, also figure out a legal pathway for outpatient services in the juvenile code. So one of the things that did happen, as I mentioned before, was a big overhaul of Chapter 55, which was a big collaborative effort with attorneys, psychologists, judges across the state. And one of the major things that they wanted to do is to have juvenile-specific language, make the code less complicated, because it was quite complicated up to that point, and it still is, but we try to make it a little bit easier, but also create a legal framework for outpatient services as well. I'm going to blow through this just because I'm running out of time. All right, so one of the biggest things that we did is to, A, make sure that we have qualified individuals to conduct fitness evaluations. Now, this was always in the code, but it was embedded. All right, so I got questions all the time. Who can do fitness evaluations? The same people that do the evaluations for adult court. It's the same criteria. It's always been the case. So one of the changes was to put that right into Chapter 55, so it's quite clear who can do these evaluations. The same requirements as 46B. Another good change that I saw was examination requirements. So what to look in evaluation. All right, so before, like I said, it wasn't uncommon where I would just see an opinion that the kid was unfit to proceed due to the IQ or due to mental illness, but no workup as to what are the functional capacities of that child. Now you are required to show your work, and it has to be developmentally informed, right? So we have to have background with the kid, explain what the kid's diagnosis is, and how those diagnoses impact their functional capacities. All right. The last thing that they have to have in an evaluation, which is a little bit different, is to provide a restoration plan. All right. So if you say the kid is unfit, that report needs to indicate what is that restoration plan for that kid. That's very important. That report is incomplete if it does not have that. Restoration options. So court-ordered mental health services. What we did was take information that was in the health and safety code, and we put it right directly in Chapter 55, so you don't have to dig for it. So you can see what are the services available for the kids. So we do offer court-ordered mental health services, which is under 5505. These are kids that are unfit to proceed due to a mental illness. That language always exists. Like I said, it was always in the health and safety code. Also, court-ordered residential intellectual disability services. These are for the kiddos who are IDD. Right, as I mentioned before, this always existed, but we just brought that into Chapter 55 directly. So the judge can order these services just as long as these criteria are met. This was something new, temporary outpatient services. This existed in the health and safety code, but it was great that it was brought into Chapter 55 as an option. So sometimes we have kiddos that do have mental health needs that need to be addressed to be able to be safe in our communities. So judges can now order temporary outpatient services just as long as it's determined that those kids need those services to remain safe. I like this part too because this was like the prerequisite to allow us to say outpatient restoration options should be developed. And it was one of the reasons why we really pushed towards having our LEAP program. So alternatives are needed because obviously, as we can see, the State Supported Living Center and the state hospital just does not have the beds for our kids, all right? So we need to find other avenues to help with restoration. So there's a lot of creative ways you can do this. Outpatient services in conjunction with education plan, like LEAP, or even placement into private facilities. We have a great collaboration. Like I said, we have a good relationship with our LIDA and LMHA. So the diversion center had a great option for us, is that we have some kiddos that are in our LEAP program. They can start out in detention and then drop down to our diversion center. So they can be in a least restrictive environment while getting services at the same time. So it's a great option and a great example of how the LIDA and the local mental health authority are working with juvenile probation. All right, so I'm going to pass it over to my colleagues who are going to show you what our program looks like.
I also like to stand. So LEAP is our Legal Education Attainment Program, and it's Harris County's outpatient fitness attainment program for youth. We started developing it in 2020. And what it's really trying to do is look at how we can serve youth. And so some of the common problems that we see in restoration for youth is, one, that they have limited knowledge, like Dr. C mentioned. They also have a limited capacity. Often things like IDD, low IQ, autism, ADHD can limit their capacity to understand or acquire information in an easy manner. They also have attentional deficits, right? They have a hard time paying attention. Y'all might be a little bit bored and having a hard time paying attention right now. We get it. It's been a long day, right? But they also have those problems. And it's really important that we work through that so that they can get the information. Finally, some of the kids that are found not fit might also have communication difficulties, both in understanding information and in communicating information. Things like autism, IDD, selective mutism, low vocabulary, illiteracy can all contribute to their difficulty understanding their legal situation. So sometimes kids need a variety of services in order to attain fitness. They might need medication for ADHD. They might need therapy in order to address the anxiety that comes up with court, or to be able to have coping skills in order to pay better attention, or to increase their communication abilities. And they need legal education, and that's where LEAP comes in, because they have to actually be taught about the legal system. Our program was based on a program made in Utah, and it is modular, meaning that we can adjust it to what the kids need. There are several other states that have programs, but this is the one that we use. All programs were originally created for adults, but we've really modified ours to be developmentally appropriate for youth. We have very easy inclusion and exclusion criteria. If a kid is not fit and they don't meet commitment criteria and we think they're restorable, they should come to LEAP. If a kid is not restorable, then there's no point in putting them through these services, right? And in our jurisdiction, we have been able to work with kids who do meet commitment criteria, but are in our detention waiting for that space in the state hospital. We have had some success with working with those kids, and others have either got in a place at state hospital or we were not able to successfully restore them in the time that we had. But it is really promising that at least some of those kids were able to be restored through our program instead of having to go through the whole state program, because as Dr. Chibueze mentioned, that takes a lot of time. For every kid that comes into our program, we conduct a suitability assessment to really understand their needs. This is based on their fitness to proceed evaluations and also meeting with the youth and the family. We create a treatment plan to really decide what order are we going to teach them this education in, how often are we going to see them, what other considerations should we have. Most often, we're meeting with youth for an hour 2 times a week, and we try and have some space between those meetings so that they have some time to see if they really recall the information they learned. We're also providing monthly updates to the court in the form of a report, and at the end of those 75 days, there is an independent fitness to proceed evaluation that is conducted to see if the kids are now fit to proceed. If they are not, then there are steps that we can take to continue rendering services. If they are, then services will end. And so when a kid is not fit to proceed, our program really follows them from the beginning. We get notifications when the issue is raised, and we work with them all the way through until either they have attained restoration or we deem that they are not restorable. And there's a lot of different steps that go through that process, including that assessment and working with our fantastic evaluators to see if kids are fit. The principles behind our program is that we want it to be interactive, we want it to be engaging. It is boring material to learn about the law unless you're the kind of nerd that we are, and we're all sitting here together learning about the law. But for these kids, it's not fun, and so we try and make it more fun. We're also trying to hit the developmentally appropriate ways of explaining information. We're making our language easier to understand. We are using different examples. We're really engaging them. We're making sure that they're not just memorizing, but really understanding the information. Our program is also defense attorney approved. The wonderful, wonderful public defender office attorneys did look at all of our program to make sure that they thought that it covered everything that they needed. And we try and make it customizable. We have had some success with having kids do this program online, though most of them do it in person. And as I mentioned, we try and decide what order youth are going to receive information, because for some of them, we really need to work on like, hey, let's behave appropriately in court first. And for others, we can save that for a little bit later. And so these are the 10 modules that our kids will eventually go through. It covers everything from why are you here? What does it mean that you have to do LEAP? All the way to testifying, how to behave in court. We're covering things from like what is a plea agreement and what is a plea bargain to who is your defense attorney and what does guilty even mean? And so we are basing this curriculum on a curriculum from the Center for Persons with Disabilities at Utah State University, and we're really trying to make it very comprehensive. When we were developing this, we were really thinking about like, how are we gonna make sure that the kids are learning what they're learning and they're not just telling us like, yeah, okay, I get it, right? And so in order to assess this, we use pre and post tests. The pre and post tests have the same questions, and they include a mix of multiple choice answers, true and false, and open-ended questions. And after much deliberation with many people doing this kind of restoration work, we have decided that 70% is considered passing. Cs get degrees, and for our kids, 70% often means that they will be restorable when they have their reassessment. Now, we certainly want them to get higher if possible, but 70 is where we aim. We do have a couple critical items within that, though, that even if you get like a 90, but you missed one critical item, like you really don't understand that the judge is a neutral party, for example, we're gonna go back and re-explain that. I will say that our pre and post tests are much better at capturing that factual information, right? The facts of it, rather than the rational understanding, which is how do you apply those facts to your case. So we train all of our providers to really work with them on hypotheticals, being able to apply it, make sure that they're not just memorizing. For that, we have interactive activities, some of which you will try in a little bit, including drawing, answering questions, role-playing, and we include a lot of hypothetical scenarios. We're documenting the problems, we're assessing repeatedly, we're making sure that they can apply it to different scenarios. Some of our underlying principles also is like we really want to establish rapport. This is a lot that we're asking the families and the youth to do, so we want to make sure that they show up. We want to identify their learning style and like, do we need to take breaks? Is this a kid that really needs to take notes? Is this a kid where we need to read it out to them, or can they read on their own? We're making accommodations for attention span and other needs, and we're trying to match their language while still teaching them the appropriate language for what they have to learn. And we're also communicating with their legal and treatment teams. So our reports that go to the court include conversations with the attorneys about like, hey, the youth benefits more when you give him written and spoken instructions. Or make sure you're not just asking, do you get it? Because this kid will always say yes, even if they don't really. As Dr. Chibueze mentioned, different kids have different legal needs. Some of them are facing certifications, some of them are facing a misdemeanor. So we want to make sure that we understand what their legal needs are in order to make sure that we are teaching to the appropriate level. There are some things that every kid needs to understand, but there are certain factors that are more important for kids with very serious cases to understand. So we're also going to cover, like, with their attorneys, what are the possible plea deals, make sure the youth understands that. Is their case going to likely go to trial? Are they going to need to testify? Even if they don't go to trial, is this youth testimony to their attorney an integral part of understanding what happened in that case? Do they really need to be able to tell you what happened, or do we have other information available? We're also covering different outcomes with them, including probation, placement, TGJD, and certification. And the other counties that work with us adapt this to be accurate to their county's information. Like I mentioned, we use a lot of hypotheticals, and so we train our trainers to use themselves as the delinquent actor in their hypotheticals. LEAP is not covered by confidentiality, so we really emphasize that. You don't have to be a psychologist or a clinician to provide LEAP. In some other jurisdictions, it's going to be people like JPOs or maybe undergraduate students who are doing this. And so we want to make sure that we are avoiding having the youth put themselves at risk with what they say. We're trying to use a variety of different scenarios and some situations which are similar to what the youth did, but also different enough that we can really assess, do they get the difference? We're trying to avoid getting stuck on specifics, right? Like maybe this one particular kid really cannot tell you what an adjudication hearing is, but they can tell you that different hearings happen for different things and they generally know what it means to be adjudicated, they just struggle with that word. We always want to start with open-ended questions, but then we can do some querying or questioning or simplifying the questions to really help kids along. And we want them to build off of their previous knowledge as they go along. One of the really exciting updates that we have to share with you is that we're currently in the process of translating our program to Spanish, and we're hoping to have that fully running by the end of the year. And we have had a lot of excitement about that. I personally am very excited about that, and this has been a really fun program to develop. Dr. Walker will tell you more about our program going forward, and if you want to run it, we also would be happy to talk more about it.
Okay, so what we want to do now is take you guys through just a quick snapshot of what the different activities in LEAP may look like. So if you want to, on your devices, go to join.nearpod.com, and then when it prompts you for a code, enter the code above, which is, I can't read it, which is KRPWN.
Interactively. It's a lot of fun, I promise.
What was the code? KRPWN. Oh, wait, go.
It starts with time to try.
Okay, and then it'll prompt you to put your name in when you get there. And you should see what we'll see on our screen here. So one of the first activities, which is my personal favorite. What? Okay. Have people joined?
I'm trying to see.
Yeah, I see some nods. Okay. So one of the first activities that's a personal favorite of mine is Time to Climb. So this is where the youth is presented with multiple choice questions, and the goal is to answer as accurately and as quickly as possible to win. So you can select a character, and then it'll join you in the queue once you're ready.
Just lots of people trying to join, so we're going to give you all a second, but thank you.
So I
for
see people
joining.
popping in.
Do y'all want to pick a character?
And then, yeah, click join. Okay, great.
This is
Oh,
what
wow,
the
lots of
game
people.
is.
Okay.
Start the game.
So we're about to start it. And again, answer as quickly and as accurately as possible. Yeah. Okay. So first question is, who does the prosecution represent? A, the community, B, the jury, or C, the judge? And you should see your little characters climb up. Yeah, if y'all can click and answer.
Play two.
Yeah, you guys have to play two in the back
Sorry, guys.
so they can see. Okay. And you should see yourself climb, and then now we're going to go to the next question. Okay, 3, 2, 1. So next question is, what is another name for the prosecutor? Is it A, defense attorney, B, guardian ad litem or GAL, or C, district attorney or DA? Good job, guys in the back. And everybody's climbing. Okay. Whose team are you, the youth, on? A, the prosecutor, or B, the defense attorney?
One more.
All right, let's go. Okay, last question. Okay, who tries to convince the court that your charges are true or guilty? A, the defense attorney, B, the prosecutor, or C, the guardian ad litem? Okay, and then it should produce our top 3. Okay, Simone, good job.
Special shout
We have
out to
nothing
guys
for
in back.
the winner other than bragging rights. But okay, you guys can switch back to the PowerPoint. Good job. Oh, sorry, never mind. Sorry, we saw more. So another activity that we have is like a drawing activity. So for this one, it's instructing you to draw an X on the aggravating factors so that a judge may consider. So the factors that the judge may consider that would kind of make you look bad in court or may increase your chances of having a more serious sentence.
So it looks like that. Thank you to the guys in the back.
So you can use your fingers to draw an X. Okay. And then we have fill in the blanks. So you're just going to drag and drop from the bank below the correct words that match the sentence.
if they were to do it wrong, it would just bounce them out. So this really gives you an opportunity to work with the youth. We're gonna skip forward just to not make them do it all.
Okay. And then we have a matching activity. So you're gonna flip the different cards and try to match it with the definition. Good job.
That's it. Now you can go back to our PowerPoint. Thank you.
Thank you, guys. Yeah. So those are some examples of activities that we use to ensure that the youth is understanding the material. Oh, geez, I gotta click all the way. To understand the material and just to check their understanding. So these are embedded in all the different modules as just more kind of like engaging ways to check their understanding. Okay. And so I just wanted to provide some case examples of some of the things that we may see with the youth that are in our program. So we have one example of a youth, Tom, who had a diagnosis of autism and ADHD. He did in-person sessions at a private placement site that was not affiliated with Harris County, but he met with his teacher in person. He was very engaged, but he was generally kind of anxious about the process. And while he showed really good memorization, it was more so kind of just like parroting back definitions that the teacher taught him, so he could understand the defense attorneys on my team, but he had trouble with more abstract concepts such as plea bargaining and when it may be advantageous to take a plea bargain versus not, or a judge versus a jury trial. And so he, because of the concrete thinking, having that, or developing that rational understanding was more of a challenge for this youth. And so they needed to kind of come up with different strategies on how to ask questions and present information. Ultimately for him, he did end up getting an extension beyond the 90 days, but then unfortunately he was found not restorable after that. And then we have Jerry, who's a youth who had diagnoses of ADHD, disruptive mood dysregulation disorder, and borderline intellectual functioning. This youth did solely online sessions because he lived too far away from our office to be able to come in person. And so that presented some barriers due to his inattention. This was actually one of my kids that I had. And so he was constantly distracted by things in his environment, going on in the home, and just had a struggle focusing in the online format. He ended up, or there was a lot of limited engagement as well. And poor frustration tolerance. So I found myself having to take lots of little breaks with him to play Connect 4 online to be able to keep him engaged in the material. Ultimately, his behavior ended up decompensating, and so he ended up meeting commitment criteria and had to go to the state hospital. So these are just some situations that we have faced here. So other challenges that we have in terms of time, it is a big burden on the families. So typically the sessions are offered twice a week for 1 hour each, and that can be a lot for families balancing work, the youth school, other children, and other responsibilities that the families have, as well as just transportation has been one of the biggest barriers when a family has limited means to come to our office. We'll also provide sessions at our local probation offices, or there's been times when the schools have allowed us to come to the school and meet with the youth during like an election period or or downtime period, so that's been helpful, but transportation is a big barrier for our families. As well as just the youth are tired after school, so we have to work with their school schedules. You have a full day of school and they're tired, so it's hard to engage them. Other consequences or other challenges are just limited consequences for the youth. Especially for the youth, they may not understand kind of what happens next afterwards if they don't participate. There's no real consequences or positives for them other than they proceed along with their case if they're found fit. And sometimes we also see that parents can have some challenges as well in terms of, even if they have good intentions, they may be presenting incorrect information to the youth, or they may at times be advocating for a youth to not participate in the program, and that's really difficult because we rely a lot on the parents. I'm going to go by really fast because we don't have much time. Thank you. And so in terms of outcomes, so once the youth is found fit to proceed, then the stay is lifted and the legal proceedings continue. However, if they reach the 90-day period and they're not found fit to proceed, there's different options. They have the option for an extension of LEAP services for 30 to 90 days. They may, as in the case of Jerry, end up meeting state hospital commitment criteria, and they may need more intensive services in a more structured setting like that. Or if they're determined not restorable, then the DA may choose to drop the charges or just pursue civil commitment. In terms of our outcomes so far, we've had 25 youth enter the program. This needs to be corrected. We've had 22 youth complete the program. So 3 youth, their cases were non-suited or dropped while they were in the program, so they didn't complete the full program. Our common diagnoses, as you can see, are intellectual developmental disorder, ADHD, and autism. And of the 22 youth that have completed the program, about 16 have attained fitness. So we have about a 68-69% fit percentile. And as Dr. Iturri mentioned, there was one youth who was originally on the state hospital wait list, and while he was in detention, we were providing LEAP services, and he ultimately was found fit after a LEAP and did not have to go to the state hospital, so that was a big success. We've had 7 youth not found fit, and 3 of those were found not restorable, and we have currently 1 youth in the program now. In terms of future directions, our goals are to expand the programs, to provide services to different counties. We're constantly doing trainings with several counties, which I'll show in a second. And then one of our goals is also to just provide basic legal education to all youth in detention, because all youth would likely benefit from some level of legal education. As Dr. Iturri mentioned, we're also translating the materials into Spanish currently, so we're hoping to service our monolingual or bilingual youth. In terms of research, for the counties that are currently using the program, we asked them to send us data from their youth in terms of their pre- and post-test results and data on their performance in LEAP, so we'll hopefully be able to publish some research in the future to assess the efficacy of the program. And then finally, hopefully expanding policy to increase awareness of the program and of the options that these youth have. Okay. And these are the current LEAP participants. If you're interested in LEAP, we have to start an MOU process, so please send an email to our LEAP email as well as Dr. Chibueze. From there, you'll have a LEAP orientation and then the MOU execution program. After the MOU is established, then there's a 2-day training where we'll teach you the kind of basics of LEAP, how to implement it, give you all of the materials that you need to tailor it to your counties and to implement it for your youth.
Yeah, just going to add a couple of caveats to that too. So LEAP is great because we have it embedded in our juvenile probation department, but there's lots of different ways that it can be implemented in your jurisdiction, because you may not have the same amount of resources. So the teachers don't have to be psychologists. I've seen jurisdictions that use JPOs. Also, it can be done with just a few individuals. We use our interns primarily for it to be done. Another thing to pay attention to is if you want to have this program, it shouldn't exist in a silo. One of the things you want to make sure is that you have collaboration with your local mental health authority, but also with your prosecution and with defense attorneys. So some of the things that they talked about, barriers, some kids may not be motivated because why would I make myself fit to proceed and have to face my charges? So some of the things that we've done is had some good conversations with the DAs is that you can show that this kid is demonstrating treatment amenability, which is a huge thing when I have kiddos that have very serious offenses, is that they've worked a program and they've been successful. And that is something that is used later down the line when it comes to disposition. Another reason why we do it is some prosecutors may not want to just drop the case without at least attempting fitness. So even though in the back of our mind, we're like, this kid can't be fit, the very fact that we have this program and gives an opportunity for us to try or attempt fitness restoration, and that gives the attorneys or the DAs a little bit of a recourse to say maybe I might be willing to drop the case. The last point I do want to make mention, because there is some work that needs to be done with the code. There's a lot of some loophole issues as to what happens when a kid is not restored. So I know we have judges in the room. Texas does not have a recourse of what to do next, so it's really up to the judges. So that is a question that probably we need to come back to the table on to figure out how do we figure out that loophole. And then also kiddos that are unfit and turns 18 while they're on restoration as well. That's another issue of how that transfer process happens. What is my opinion? In regards to, well, I've seen other jurisdictions, they have some opinions as to what to do with the charge. So some of them actually may mandate treatment into a certain period of time and then they'll drop the case. Now, there's something to keep in mind too, is that when a kid is unfit, you order a stay. Well, the stay happens when you order the evaluation. And so some people argue, can you order some things when you have a stay in place? All right, so that's also an issue at hand. So I do think there's a lot of work with the code to figure out what are some of those loopholes that we need to indicate, okay, maybe we could order treatment for a certain period of time to mitigate some of the DA's concerns, and then at that point you can drop the case. Oh, it's free, yes. Yes, does not charge anything. And actually the way that we've done it, we've used the resources that we have in-house to make it happen.
Well done. Thank you. My hat is off. All three doctors, Chibueze, Iturri, and Walker, well done. And this is so next level. If you've been doing this for some time, you're aware of the Mahea testing that this is so substantive and so deep and so well thought through with respect for the child and the legal process and their true understanding. I just cannot believe how next level this is. Really, well done. My hat is off to all three of you. Thank you.